Hi, everybody. We're really pleased to be here. I want to thank Karl, Racine, who's been an outstanding partner in this case from day one, and say special thanks to Karl, his Solicitor General, a tool from my office, and Noah Bookbinder and the folks in the crew. Today, we thought was a very good day for us. The question is whether the Justice Department president can use a writ of mandamus to do an end run around the district court judge's decision. That was the primary focus, I think, of the questioning today. But as was very apparent, they got to the merits in a number of different ways. And the attorney for the Justice Department, Mr. McCann, conceded that their position is that the only way that we could hold Donald Trump accountable would be to have Congress pass a law and say that, you know what it says in the Constitution, that flat prohibition about that Congress has to say the same thing all over again. I don't think that's a tenable position. I don't think the judges on the panel are going to buy that argument. I certainly hope they won't. The emoluments clauses are flat, clear prohibitions on the President of the United States, and they prohibit him from using his office for profit. They prohibit him from putting his financial interests above the interests of the people of the United States. And I don't think Congress has to reiterate that in legislation. And the court well knows that that will not happen in this era. So we believe they will come to our point. They will hold the president accountable, and that no president in the future will have any question whatsoever about whether you can profiteer from the White House, whether you can direct the G7 or any other group of countries to come to your resort and pay you because you're president. What we expect now of this court is a decision on whether or not the writ of mandamus was an appropriate vehicle to raise this question in the Fourth Circuit. But the other questions about the president being above the law are absolutely implicated and dependent upon that decision. And I thought our lawyers did an outstanding job today. I hope and believe there was great interest in that in court.
Thank you, Brian. I, too, on behalf of the District of Columbia, want to thank Brian Frosh and the entire team at the Maryland Attorney General's Office for being such a good, strong, and consistent partner on this case, and certainly other cases in which we work together. Today was really about the rule of law and whether the president is above the law, both in terms of the substance of the emoluments clause as well as the legal process that brings us to the Fourth Circuit today. What we know is that the framers were absolutely clear that they did not want to have the influence of foreign government money in our government. That's why they included in the Constitution our country's first anti-corruption law. That's the Foreign Emoluments Clause. Of course, the Domestic Emoluments Clause also forbids the president from receiving monies from states who would seek to curry favor with the president. We know that foreign governments, and we have a good example recently with the phone call with respect to President Zelensky of Ukraine, they absolutely want to ingratiate themselves with the president. And they oftentimes refer to doing business with the president's hotel. That is barred by the Constitution, as we assert, And that's why we brought this lawsuit. With respect to the process, most legal cases proceed with the filing of a complaint before court, as we did here with our filing in the Federal District Court in Maryland. Once a court, as happened in our case, decides that a case can go forward, rejects a government's motion to dismiss our case, the case usually proceeds through discovery and then on the merits. The losing party then gets the opportunity to appeal that decision from the district court. Here, the president sought an unusual and extravagant and rare legal maneuver, a motion for mandamus, to short-circuit the normal process of a case. We're hopeful that today's argument will lead to the district court getting back the case and allowing us to proceed with discovery to a final judgment from the district court. We're confident in our case. We think the arguments went well today, and we're hopeful that the Fourth Circuit will send the case back down to the Federal District Court. Thank you.
No one say? Sure. I just say very quickly, I want to thank Attorney General Racine and Attorney General Frosh for really having the foresight to bring this case when we were only just starting to learn about the kinds of influence and corruption that we had to worry about with the president's maintaining these businesses. The years from then till now have only shown how prescient that was. All that Maryland and DC, I think, want is to be able to bring this case in front of the district court and prove the case, and hopefully today was a step in that direction.
If I could just make one other point, and I think this is a point that was discussed today in court. A lot of folks criticize Ryan, Frosh, and myself for being anti-Trump. That's not our position in this case. We are pro-Constitution. We are pro-anti-corruption. And as a few of the questions made clear, the issues that we're confronting in court today will not only apply to this sitting president, but to all future presidents. And the fact is, and I think the Constitution makes clear, we want our presidents to be focused every minute of every single day on the people's business, not their personal business.
Questions?
Happy to take questions. Please, if you could just introduce yourself so that we know who you are as well as the cameras.
Sure, I'm Denise Lavoie with Associated Press. The president's lawyers seem to just hit over and over again that the president can't be sued in his official capacity unless there's a statement/authorization from Congress. What's your response to that? And then the second part of the question, how unusual is a writ of mandamus? They call it extraordinary. And could we get a layman's explanation of what a writ of mandamus is?
Sure. Brian, do you want to take one or the other?
Go for it, and then I'll
Okay. With respect to the mandamus, mandamus is an extraordinary remedy in law. And the standard is extremely high. Because again, the way in which cases are to proceed is that they're to proceed in the normal course of things after discovery, after a judgment. Then you get to go to the appellate court. Mandamus is reserved for those circumstances where the decision below is so obviously wrong that a grave injustice would apply if it were not immediately corrected. There's no doubt that the emoluments issues are unusual, rare, important. There also is no doubt that Judge Massetti's decision was thoughtful, well-reasoned, and certainly not obviously wrong. And so that's why we think the mandamus motion should fail, and we should be right back in Judge Massetti's court, hopefully this spring.
Now, let me just add to that. The language of the cases is that the judge has to usurp his authority, or so indisputably exceed his authority that a writ of mandamus and extraordinary writ is warranted, and it just is not the case here. And the Justice Department, to address the first part of your question, the Justice Department says that Congress has to pass a law in order to give effect to the flat prohibition, very clear prohibition in the Constitution of the president using his office for profit. And everybody, they conceded that, of course, anything in the Bill of Rights gives private citizens, gives entities that are, whose rights are affected, the ability to go to court and vindicate those rights. And there are many other provisions in the Constitution that give rise to the same rights. And the notion that Congress has to somehow make clear what the Constitution says in the Emoluments Clause, I think is just wrong. It's a clear, simple prohibition on the president and other federal officials in the Foreign Emoluments Clause receiving presents or emoluments of any kind, whatever. Now, the word emolument isn't, or wasn't until Donald Trump became president, so much in the commonweal, but the framers had a very clear context for it. There was a professor, John McHale at Georgetown University, who surveyed every dictionary in print from 1604, I think it was, to 1804, and all of them used the definition that we use, profit, gain, or advantage. A couple of them, I think 3 of them, had a narrower definition, but they also included the definition that we argue for. And if you look at the context of the word in the Constitution, if you look at the way it was used at the time the framers wrote the Constitution, it's very clear it was meant to be broad. It was meant to stop the president and, in the case of Foreign Emoluments Clauses, other federal officials from using their office for personal gain. And the whole purpose was, as Karl said, to ensure that they're acting in our interests, not in their interests. And, Donald Trump actually has asked Ukraine and probably other countries for favors. And we can see by what he's done openly, and the G7 is a great example of it, where he said, I am going to have these 7 countries come and stay at my resort. The only reason he backed down, and one of the judges referenced this, was because of public pressure. But, and I'm pretty sure the size of the parking lots didn't decrease, or the proximity to the airport didn't get any broader. Nothing changed except for Donald Trump got embarrassed, ultimately. Really a hard thing to do. But the point is that this president has flouted the Emoluments Clauses for his entire term in office. He now calls them phony. And the fact of the matter is they're there for a reason, and he is violating them as no president in our history before has ever done.
If I could just add to your point there, the position that the Department of Justice articulated today in court is entirely consistent with the position that is taken on so many issues. Namely, that the president is in effect above the law, that there is no check and balance legally on the president of the United States. The course of history, the Constitution, the Federalist Papers, even Supreme Court cases make clear that in the United States of America, a country that decided to not have a monarchy, no one, including the President of the United States, is above the law.
But What impact, if any, is the decision by the Trump Organization to sell the lease to the hotel? Will that have any impact on this case at all?
I think it's an interesting question, and a lot of it is going to obviously depend on how it is sold, to whom it is sold. It would be an interesting question, would it not? If the hotel would be sold to a foreign sovereign or a group that had foreign sovereign funds. Look, the president has always had at his disposal the ability to end this lawsuit. All he needs to do is to fully, transparently, and firmly divest himself from the Trump Hotel. That would eliminate the lawsuit. He's obviously chosen not to do so, and until that happens, we will persist in our efforts.
I just won't yell.
How would Paul on that actually? Let's say he just sells it to like a private equity fund or a hedge fund, and it's fairly clear that it's not, there's no state or federal government money. What happens to the lawsuit if he does that in 2 months or 3 months or something?
So it's quite possible, depending on the circumstances, Karl said, that it could move the lawsuit. And when we filed our suit, we said that we had standing for all of the Trump properties. And the district court judge limited our standing just at the Trump Post Office Hotel. So, what he's doing with Mar-a-Lago, what he's doing with Doral, what he's doing with Trump Tower, what he does with his condominiums and commercial office buildings where he has leases with China and India and Afghanistan and many other countries. Those are all still violations of the emoluments clauses. The Trump Post Office lease itself is, of course, a violation of the emoluments clause, and letting federal officials receiving a benefit is a violation of the lease itself. So this lawsuit could be mooted if Trump disposed of his interest properly in the Trump Post Office Hotel, does not address the claims that we've made with respect to the other properties, but insofar as the district court's ruling, it would move the case for the Trump Post Office Hotel.
The only thing I would add to that, Jonathan, is if that happens in a way where the property is sold and there's no foreign sovereign monies in that, I think the victor is the United States Constitution, because the emoluments clause will have been vindicated.
So,
Do you reach a similar situation with mootness if this case continues to stay in court and there isn't a second term for this president?
I'm sorry, I didn't hear the first part of it. Would you say
Do you reach a similar situation of mootness if this case continues in court and is continuing litigation and there is no second term for this president?
So if Trump loses but the case is still alive, what happens to the case? That's what you're saying.
Yes.
If I got it. If Trump loses the case. I think in circumstances like that, it could be moot because he'll no longer be president. We have not asked for relief in the form of a clawback of the monies that he has made. We're just saying the courts should stop him from violating the emoluments clauses.
And Sharon.
Did you get a sense of whether the court was leaning towards sending the case back down to the lower court so they could certify it for appeal to send it back up here? Because there was a lot of discussion about how unique the court, the case is, and whether they should have skipped that step.
I'm really reluctant to speculate on what the court is going to do. They have a number of different options, of course.
They could do that.
They could. And they could, they could affirm they could do the same thing that the panel did, dismiss our case with prejudice. I think that was wrong, but they could do that. They could say, okay, you guys win, the writ of mandamus is wrongfully granted, and we're sending it back to the district court. Go ahead, full speed. They could send it back down with conditions. They could send it back and say to the district court judge, we want you to think about the certification motion that the government had written and consider the following things, or just rethink it, reconsider it. So
If they do the last thing, then is it your case in the same status as the DC?
well, that is essentially what the DC Circuit did in Cook Prison.
We're going to take just one more.
To clarify on what Sharon's asking about, so say they were to send it back down to certify the writ in the same fashion that the DC Circuit took on the congressional case. What does that do to the discovery that is on hold? What is your read of where the discovery stands at this particular point? What happens immediately when there's a ruling?
You know, I mean, we're making it more and more hypothetical here, but they could do one of a number of different things. If they send it back and say we want you to rethink certification, they would likely say hold up on discovery until you're done with that. But they could also say rethink certification, but go ahead with discovery. I mean, they could do. This is the United States Court of Appeals. They can do almost anything.
And would there be a stay in place?
There could be. I mean, there's a stay in place now that was granted by the Fourth Circuit. And their decision will either leave that in place or remove it.
Your preference would be for it to be sent down to the district court to proceed to trial or to?
Yeah, big green light.
Okay.
Let me add on that. Absolutely. What we're asking this court to do is to send the case back to Judge Massetti to remove the stay on discovery. You'll remember that we issued, I believe it was 38 subpoenas. No subpoenas issued to President Trump himself. We would proceed, as we've outlined in our discovery plan, to really have swift discovery, and then we would proceed to file a motion for summary judgment where we would argue that we have established that the President has violated the Emoluments Clause. We think all of that can take place expeditiously as soon as the court, if it's inclined to do so, sends the case back to Judge Massetti.
Thank you, everyone.
Thanks a lot.
Thank you.
Thank you.